Last class we have been discussing about what is a contract, what are the essential elements of a contract, and then we moved on to what is the different classifications of contract. If you remember, there were three types: formation, validity, and as well as performance of contract. We have discussed various types of classification of contract along with different examples. I hope you have no doubts with respect to that. Moving on, we'll be studying individually offer, individually acceptance, consideration in detail from today. So the first thing today we'll be studying is offer. Now, according to the Indian Contract Act, what does offer is defined? When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Okay. Now, this is a definition according to the Act or Indian Contract Act. Now, what you need to remember is an offer or a proposal is where you telling your terms and conditions to the other person that you are willing to enter into the contract with the other person. Example here is Mr. X offers to sell his computer for ₹25 to Mr. Y. Okay, it is only an offer. Now, the example does not signify whether Y has agreed to purchase a computer or not, but X is what? Signifying his willingness to have a contract with Mr. Y. So, that is called as an offer. You are just giving your willingness or you are giving your decision to enter into the contract with the other party. The terms and conditions here are what? To sell. What are you selling? Your computer. At what price? At ₹25,000. So, this statement is called as only an offer. So, this is another important section C question. Students, essentials for a valid offer. It can be intention to create legal relations. It has to be in definite terms, statement of intention and invitation to offer. Offer must and should be communicated to the offeree. Conditional offer to be made known. Special or general offer. Cross and counter offers. So, all of this and many more we will be studying shortly. Let's move on to the first one. Today we'll be discussing, students, three important cases with respect to the essentials of a valid offer. The first one, it must have an intention. That means both the parties entering into the contract must have a legal intention to create. What is it? An offer must have an intention to create legal obligation, and not all offers are legal. For example, social offer, domestic agreements, etc. As I told you in the beginning of the classes, right? In inviting your friends to go on a picnic or inviting your friend to meet in your house for a dinner, etc. All these are social agreements. Every day we come across so many agreements. Not necessarily all these agreements are going to be turned up as what? Contracts, because we didn't intend to create a legal relationship over here. Here we are going to discuss about the case Balfour versus Balfour, which I've already, we have already told this case during explanation of intention to create legal relationship in essentials of valid contract, right? Now, here I said who two people are going to have the same surname. It has to be siblings of the same family, or it has to be a husband and a wife. That's right. Here the case we are talking about is husband and a wife. Now, husband lives in Ceylon and wife lives in England over here, and husband promises to pay £30 as a maintenance purpose for a house every month. Okay, so husband agrees to send £30 to his wife for maintenance purpose. Now, for some reason, husband stops to send or refuses to send that £30 of money to his wife. Now, what does Mrs. Balfour do? She is going to file a case against her husband. Now, the court, what is the court's decision here, or what is the court's judgment over here in this case Balfour versus Balfour is? The case was dismissed. Why? It was just a social agreement between a husband and a wife, neither of the parties, that is neither the wife, neither the husband actually intended to create a legal relationship. Did the wife decide, if my husband in the future is going to stop giving me the 30 pounds, I am going to take him to the court of law? No, that was not the first intention. On the other side, even husband, when he started to or decided to send rupees 30 pounds to Mrs. Balfour, he never intended to take her to the law of court if he fails to do so. Therefore, the court has dismissed this case and the wife cannot claim any damages in this case, reason being both the parties never intended to create a legal relationship. Okay, so the first essential to a valid offer is what? Both the parties must have equal intention to create a legal relationship. The second offer or the second essential is, offer must be communicated to the offeree. Now, if I am offering to sell my computer to you at rupees 25,000, I must communicate it to you. What say if you are not unaware of that offer? Then that cannot be called as a contract. For a contract or an offer to be valid, it must be communicated. An offer to be completed must be communicated to the person to whom it is made. Let's look at this very interesting case. Lalman Shukla versus Gauri of the year 1913. Now, all these cases that we are discussing here, it is actually from the English common law. You know how Indian contract came into picture, right? It is always derived or based on the English common law. So, all these cases are reported in the English common law. So, what does this case talk about? Now, who are these two people? Basically, let's learn the relationship between Shukla and Gauri. So, Gauri is the master and Lalman Shukla or Lakshman Shukla is the servant of Gauri. Okay. So, Gauri is the master or the owner and Shukla is the servant. Now, what happens in this case is, Gauri's nephew goes missing. So, his nephew boy goes missing and therefore, he sends a servant to go find his missing nephew. And meanwhile, when the servant is away fetching for his missing nephew, what Gauri makes is, he puts up an ad in the newspaper. He announced a reward of rupees 500 to those who find his missing nephew. Remember this? His servant has already gone to find his missing nephew. Meanwhile, Gauri has announced a reward to whoever finds the nephew. So, meanwhile, all this is done. The servant Shukla actually found his missing nephew and brings him home. But at this point of time, please note, Shukla is not at all aware of the reward that is announced by his master. Shukla is not aware of the reward announced by his master. So, is there a communication of the offer over here to the servant? Absolutely not. Communicate has not happened over here. So, let's see what the servant does. So, Shukla, what he does is, once he comes to know or he is aware of the reward given by or announced by his master, he thinks it was he who brought the missing nephew to home. So, he rightly deserves that reward. So, he goes and files the case against his master Gauri in the court of law. Now, after court hearing from both the parties what their defenses are, the court decides the servant is not entitled to the reward, as he did not know about the offer. As I told you, when the servant was away fetching his missing nephew, it was announced. So, therefore, the offer was not at all communicated or informed to the servant Shukla. And also, what Shukla told in his defense is, but what does the reward say? Reward says, for those who find his missing nephew, it is the reward for them. I have found the nephew, so it definitely belongs to me. For which the court had to say, or for which Gauri had to say, that finding the missing nephew, as a servant, it is your duty to do whatever your master is asking you to do. It does not necessarily have to be a fulfillment for a reward. Hence, the case was dismissed. Hope you understood this case, Lalman Shukla versus Gauri. the offer is absolutely not communicated. Therefore, if offer is not communicated only, how can he accept the offer and how can he enter into a contract? Therefore, communication of the offer to the offeree is very much essential. The third essential part is quotation of price is not an offer. Now, quotation all of us know, right? Now, companies actually given a quote. I want to build, go down. Now, this is the quotation that I am going to give you. Are you willing to construct the building or construct the go down at this particular price quoted? Okay, it is just quoting. I am nowhere agreeing to the terms and conditions or giving you a confirmation this is the final price. I am just quoting. It's just a estimation. Let's look at the meaning. A quote is not a binding contract. Because why? It's just an estimate. I am not confirming anything here. Under contract law, only offers are considered legally binding and a quote is definitely not an offer. Let's look at another interesting case here. Harvey versus Facey. Now, what is the relationship between Harvey and Facey? Facey is a wealthy landowner. Okay, I have just displayed a home over there, right? He is a wealthy owner and he wants to sell that home or that villa that belongs to Facey. And Harvey is just a person, an ordinary person who is interested to buy. So, what Harvey sends? Harvey sends a telegram to the Facey. Will you sell us Bumper Hall pen? Now, what is this Bumper Hall pen? It is the name of the house. Okay, it's not a written pen or something. Bumper Hall pen is what? The villa or the building's name. It's the house name. The second question is asked is, what is the lowest price? Please note, Harvey has asked Facey two questions. First question is, will you sell us your home? Second question is, what is the lowest price? Note that, okay, two questions. For which Facey sends a return telegram as a reply says 900 pounds. Please note that it is 900 pounds. For which Harvey again replies, I accept the offer, please send us the title deed. Let's go back. How many questions did Harvey ask? Two questions. Will you sell us your home and what is the lowest price? Facey answered what? 900 pounds. What do you think is the answer for which question? First question or the second? Of course, the second. Now here 900 pounds is only an answer to the second question and the question was what is the lowest price, and Facey never confirmed in his reply in the telegram that he is willing to sell. Yes, I agree to sell. Nowhere we can see the confirmation from the Facey. He just quoted a lowest price as asked by Harvey, but he never informed or he never communicated that he is willing to sell. Therefore, the court dismissed the case saying that mere quoting of a price or the lowest price does not constitute offer. Hope you have understood. Here, there was no confirmation about the willingness for the owner to sell his house. He just quoted a price. Is that clear? So, this case is about quotation of price is not an offer. The fourth one, an offer may be positive or a negative. It's a very simple essential part over here. A positive offer is to do something. Opposite is what? A negative offer is to abstain from doing something. Two simple examples here. For a positive offer, A agrees to buy the car for rupees 50,000 from Y. Okay, he is performing something or doing something in order for the entering into the contract. That's called as what? A positive offer. You are doing something. There is some kind of action or performance of activity over there. On the other side, what is a negative offer? Negative offer is A agrees not to build a compound around his building for rupees 10,000 to Mr. B. So, B says to A, if you are not going to build, if you are going to stop or not build a compound around your building, then I can use that space for something else, for which I am going to pay you a sum of amount of rupees 10,000. So, is Mr. A is performing anything here? No, he is abstaining from performance, or he is not doing or abstaining from doing something, which is called as a negative offer. Is that clear? An offer may be positive, where you have to perform certain actions or duties, and opposite is a negative offer, where the parties abstain from doing something or performing certain activity. So we have come across what is an offer, essentials for a valid offer. Today we have discussed 4 points. Number 1, intention to create a legal relationship. You also need to remember cases, students. Cases also is important. When you remember the case, easily you will remember what is the content of the point. Balfour versus Balfour. Second, offer must be communicated to the offeree. Here we discuss about the case Lalman Shukla versus Gauri. Number 3, we discuss just quoting of a price is not an offer. The case we discussed is Harvey versus Facey. Number 4, an offer may be positive or negative. Okay, so these are the first 4 essentials of the contract. Yes, Bindu, I would like to clarify your question now. As we have discussed in the last class, if you guys remember, classification of contract, right? There we studied about the validity of the contract. When you're signing, or the person with whom you're entering into the contract, you must be able to make sure that the person is in the right terms, right? As I told, the capacity of the persons, if you remember, one of the essential element of the contract is capacity of the persons. That means mentally he must be capable, legally he must be capable, and in terms of age above 18 years. The question here you are asking is about the mental capacity here, right? That the person should not be unsound or lunatic. Now the question you are asking is that he must be, if Mr. A is a lunatic person, and then another party comes and falsifies him and makes him sign the agreement to construct the house or a property, and then over a period of time that he turns into a normal person, the lunatic turns into a normal person, and then he understands that he's been cheated, and then your question was, can he sue the other party because he was being cheated? The answer is yes. Reason being, at the time of signing the contract or agreeing to the terms of contract, Mr. A was not in his conscience, or I would say he was not in his normal conscious. He was, I would say, as his unsound mind, his decisions, a person when he is in an unsound mind, any decisions taken by that person cannot be termed as legal, or cannot be taken with respect to a contract. Therefore, Mr. A can definitely sue the other person and then claim the damages or claim the compensation that he has to be received for being cheated or for being falsified. I hope you have received the answer for the question, Bindu.